As we transition from the Revolutionary War, we quickly begin a new relationship once again with American Indians in the new nation. We laid down in the previous PowerPoint that the first laws that were passed were Trade and Intercourse Acts, which basically stipulated that Congress had the right to make treaties with tribes, as well as they were the only ones who had the right to allow certain traders to go on tribal lands and to trade among and with tribes. Now in this new nation, we're going to talk about what that looked like, how it changed very quickly, and what happened once the Louisiana Purchase took place. So what does diplomacy in this new nation look like? So southern states very quickly let it be known to the federal government that they felt like treaties were an impediment to growth. New settlers were coming to settle in Georgia. Tribes were being pushed off their lands. Settlers were making negotiations with treaties and tribal members. And it quickly became very apparent that there was going to be a huge conflict between settlers and Indian nations trying to regulate land and figure out how that was going to happen. So as early as 1789, Henry Knox, who was the Secretary of War for Washington, feels like removal is really the only policy that's going to work for the federal government. So fast forward now about 10 years, and the Louisiana Purchase takes place. The Louisiana Purchase takes place in 1803, and as you can see in the map, we acquire a large portion of territory. Having read the chapter, hopefully you've read about the Lewis and Clark expedition, how American Indians helped Lewis and Clark on that expedition, and the relationships that were formed during that expedition. What also became apparent, however, was that a lot of the territory was not agriculturally fit, and so it was even more important for the federal government to be able to allow people, the new settlers, to have the land that was already Indian land in the East. So throughout the span of 1803 to 1827, we're going to focus now on the Cherokee and their experience in particular. While things were happening with other tribes throughout the United States at this time, we want to focus in on the Cherokee because we're going to look specifically at some outcomes that happened as a result of their interactions right after the Louisiana Purchase. So between 1803 and 1827, the Cherokee make 3 new treaties, ceding a large portion of their land. So their land originally covered about 5 states, or territories within 5 states, and by 1827, their territory was now within the area of Georgia, and Georgia alone. So the Cherokee Nation were unique and have a unique story just like other Indian tribes. What was unique about the Cherokee is they had adopted a lot of the practices that the federal government asked them to adopt. They kind of took to heart this idea of civilization and what the federal government's idea of civilization was. And during the time period between the American Revolution and the Louisiana Purchase, the Cherokee Nation developed their own constitution. They have several economies, a very prolific agricultural economy. They hold slaves. They have their own formal government with a legislature and court system. And they also developed their own written language, having published also during this time a lot of newspapers. So in terms of civilization, and that as an argument in order to move them out of Georgia territory, as you can see, the Cherokee Nation, in terms of civilization by American terms, were quite civilized. So something else happens during this time that really starts to push forward this idea that the Cherokee need to be removed from their land. So in 1827, gold is discovered on Cherokee land. That causes a lot of people to have the idea in their mind that they want to have the Cherokee removed from that land so they can get the gold. We see Georgia, in an attempt to get the Cherokee off their land, to enact a series of laws that causes the Cherokee Nation to eventually go to the Supreme Court. So the Cherokee are basically within the confines of Georgia, Georgia decides to enact a series of laws. The first saying that by Georgia law, Cherokee Nation, we abolish your government. They also say, Cherokee Nation, we're going to divide your land among 5 counties within Georgia. Finally, they say things like, we're going to forbid your courts and legislature to meet, and we're going to extend our own law, Georgia law, over Cherokee country. So while this is happening, Georgia passing all of these laws, attempting to impose their laws on the Cherokee Nation, the federal government is also starting to think about removal. So what's going on in the government's mind during this time, and here is a little bit of the rationale in Congress and some of the debates that come up during this time, is that Indians are primitive hunters. They should not stop the advancement of civilization, of settlers. By removing Indians, they would actually be allowing civilization to move forward. Other people, like missionaries and people who were opposed to removal, felt like maybe it might be the only way to save Indians. We have others like John Adams saying, we've taken their hunting grounds, Indian nations that is, and we need to move them now to places like the West where they can farm and create their own communities where they can become civilized. Finally, the person who is ultimately the one that pushes the hardest for removal is Andrew Jackson. And his argument is that we can't allow foreign governments being Indian nations, to establish themselves within a state boundary without the state's permission. So his argument is that the Cherokee Nation had not gained permission from Georgia and therefore should be removed from Georgia. So what arises from this is a couple of cases that are founding cases in the area of federal Indian law and serve as guideposts for federal Indian law. So what it does is it defines Indian nations in terms of who they are within America and how they're going to be treated and interacted with. So the first case that we're looking at is Cherokee Nation versus Georgia. Some facts of the case: George Tassel, he was a Cherokee convicted of murdering another Cherokee on Indian land. He is taken to court by the state of Georgia and tried within the state of Georgia. He is charged and convicted with murdering another Cherokee, and he has done so by Georgia instead of the Cherokee Nation. Cherokee Nation says, no, we have laws. It's an Indian who murdered another Indian, and he should be able to come to tribal court. So what happens is George Tassel applies for a writ of habeas corpus from the Supreme Court. So here are some questions that are answered within the Supreme Court decision and why it plays a foundational role in federal Indian law today. So the first question is, what is the significance of treaties between Indian nations and the federal government? The second question, what is the relationship between Indians and states? And finally, to what extent, if any, is self-government retained by Indian nations? So in the court's analysis, the first question that comes up is the Cherokee Nation a foreign state in the sense in which the term is used in the Constitution? By answering this question, the court looks at whether or not they have jurisdiction over this case. So in their analysis, the court says, well, in the past, tribes have really been treated as states since settlements. We've signed treaties with them, we've negotiated with them, kind of like we do with states. The secondary question, though, is where kind of the bigger issue arises. Do the Cherokee constitute a foreign state, then, because we've signed treaties with them in the sense of the Constitution? And this is where the idea of domestic dependent nation comes in. So in the court's analysis, they say, hey, tribes reside within the boundaries of the United States. In that they reside within the United States, they have voluntarily ceded their lands to other countries, namely the French, the British, and the Spanish, in treaty negotiations. However, in their negotiations with us currently, they look to us, even though they signed those treaties, for protection, address the president as a great father, and ask for help. They're given different provisions and supplies as part of that treaty. So on top of that, other nations, now that we are the United States, don't ask tribes to make treaties with them. There are only treaties made between the United States and tribes. So from this comes the idea that Indian tribes are domestic dependent nations. They are not foreign nations, but they do have an identity which is separate from states. The outcome of this is that the Supreme Court didn't actually rule then that they had jurisdiction, but they did hand down, much like Marbury versus Madison, this idea of domestic dependent nations. So shortly after this case, Tassel, the Cherokee who murdered another Indian on Cherokee land, was actually hung by Georgia. And what happens a lot during this time is that there is some disparity between what happens in the Supreme Court and the outcomes that happen as a result of them within states. The other seminal case during this time is Worcester versus Georgia. So Worcester was a missionary in Indian land. Georgia says that non-Indians, namely here a missionary, needs a license from a state to be on Indian land. Worcester was not on Indian land with a license, and therefore he was condemned to 4 years of hard labor and a Georgia prison. So what comes up is Cherokee Sioux saying that that's not the case. He was on Cherokee land, and the Cherokee should have the ability to make their own laws about what happens on their land. So in the court's analysis in this one, what happens is they go back to Britain's charters. They consider what Britain, as one of the founding people to make treaties with Indians, what was their intention when they made those treaties? Well, the very act of making treaties shows the court that Indian nations were capable of maintaining relations in peace and war. They governed themselves. They made those treaties with Britain, and they, however, made those treaties, but they were under Britain's protection. They continued to negotiate, as we know, during the Revolutionary War, playing different sides, making their own decisions, and all of that comes down to tribes being separate from states. So the next thing that the court looks at is that the federal government and the federal government alone in the Constitution has the right to manage Indian affairs, trade, and regulation. We see that through the passage of the Trade and the Intercourse Acts. In that, they are treated as nations. Indian tribes have the ability through negotiations with Congress to make those treaties. Their rights are protected within the treaties. And finally, as we know, the only people that they are supposed to negotiate per the Trade and Intercourse laws is the federal government. So the outcome of this case is that the Cherokee Nation is recognized as a distinct community, which occupies its own territory, and ultimately the laws of Georgia have no effect in Cherokee country. And on top of that, in this case, the citizens of Georgia have no right to enter Cherokee country. So the court rules in Worcester versus Georgia that the state of Georgia's actions are void. They can't say that people have to get a license in order to be on Indian land. However, the outcome of this one, much like Cherokee Nation, is that Andrew Jackson, makes the court decision impossible to enforce. As we know, what happened shortly after these cases is the Indian removal. And as you have read in your chapter, what happens as a result of that is that tribes are removed. Other Cherokee Nation members do stay on their lands, but there is a devastating effect on the Cherokee during this time as a result of the removal.